The American founding culminated in the drafting and the ratification of the U.S. Constitution. We've talked throughout this course about constitutional theory and constitutional history, going back to Aristotle, the ancients, as part of a conversation about law and justice. We should ask how the U.S. Constitution would look in the broad context of the history of constitutions and constitutional thought. How does the U.S. Constitution, in the broadest structural terms, compare to the ancient traditions of constitution making and the British Constitution? Because the American experience of making a new constitution, of creating a new regime of supreme law, drew both from the experiences of classical antiquity, as those had been refined through modern political thought, and they drew from the experience of the British Constitution to create a new synthesis that drew from both of these sources, but was in many ways a departure. The first thing that an observer, either from classical Greece or Rome, or even from Britain, would observe about the U.S. Constitution is that it's a written constitution. The Roman Constitution, for example, the famous republican system of ancient Rome that included the magistrates, the Senate, and the assemblies, was nowhere a written constitution. The same with the British Constitution. It was a collection of organs, of institutions, of historical rights, of various bills of rights, but it wasn't specifically a written constitution. There was no singular document. And in this way, the American Constitution is a distinctive departure from everything that had come before, the idea of a written text that defines what we earlier described constitutional law as, a sort of second order of law. At the very beginning of this course, we defined constitutional law as a higher order law, as a set of rules for making rules. We distinguish between ordinary law, statutory law, common law, the rules that apply to govern a society that are enforced by the state. And then we described a second order of rules, constitutional rules, the rules for making those primary laws. And so the American Constitution would depart by having this second order of law in written form. Moreover, the U.S. Constitution was not only a written constitution, it carried with it the idea that constitutional law was supreme, and the idea that there was a specific second order of laws that prevailed over any primary laws. And so the idea of a supreme law of the land was in many ways itself also a departure. In fact, in this sense, we can contrast it very directly with the ideas of sovereignty that were expressed, for instance, by Thomas Hobbes in the Leviathan. This idea, which was common in England and the colonies in the 17th and 18th century, that there must be a supreme authority, that there must be some institution or individual that has the highest power because they are sovereign. The Constitution, the U.S. Constitution, rather, operates under the principle that the text itself, the Constitution itself, is supreme over any sovereign institution or individual itself. And so the Constitution itself, as written, prevails over any other claimant to be the sovereign. The U.S. Constitution was grounded in the idea of popular sovereignty, and indeed a national popular sovereignty. Its preamble declares, "We the people," and so it embodies the idea that government derives its power from the consent of the governed, and in this case, the governed are the people of the United States collectively as a whole. The U.S. Constitution embodies the idea that it enumerates the powers which are granted to the various branches of the government. And so it operates with the idea that the people cede this power to specific institutions in specific ways. It enumerates the powers of the various organs of government. But at the same time, one of the most prominent features of the U.S. Constitution is what would come to be known as the Bill of Rights. Now, ironically, the Bill of Rights is not part of the original framers' design, if by the framers we mean the collective of men that gathered in Philadelphia in 1787. In fact, the Bill of Rights was included because the opponents of the Constitution, principally the people who came to be known as the Anti-Federalists, feared that the powers vested in the national government by the Constitution were too dangerous and required the explicit protection of individual rights. And this marks another distinctive feature of American constitutionalism in the late 18th century, the protection of individual rights as part of a constitutional arrangement. Now, in specifying their rights, the Americans drew on a deep well of British tradition. Their rights that they protect were part of a tradition, a heritage of English rights. And it's important as well to note that the English had protected their rights in various historical acts, like the 1689 Bill of Rights. The U.S. Constitution draws on this tradition, and specifically a part of that tradition, a Whig conception of that tradition, in which these Bills of Rights, including the U.S. Bill of Rights, are not grants of rights from a sovereign king or government, but are in fact guarantees of rights. And the U.S. Bill of Rights is meant as a set of guarantees. The Bill of Rights isn't a grant of rights. There isn't some prior sovereign that grants individual rights to the citizens. Instead, the citizens originate in a state of freedom. They have a kind of natural liberty. They cede certain powers to the government, but they declare that certain rights are reserved, that the Bill of Rights guarantees the natural liberties of the people. And so many of those who have a role in the shaping of the Constitution are careful to insist that the Bill of Rights is not, in fact, exclusive. These aren't the only rights that people have. The rights originate in their natural freedom, but these are a specific set of guarantees that are meant to check the powers that are enumerated in case there is some residual danger that the powers which have been given are too excessive, that they could somehow intrude on the natural freedoms of the individual. And that in itself is worth pointing out as well, that the U.S. Constitution, especially in its Bill of Rights, protects the freedoms of the individual, that it guarantees individual rights. And this would have seemed alien, certainly to the ancient tradition of constitutions. In the instance of Greece or Rome, the various republics of the ancient world that live under different constitutions, there is never an enumeration of individual rights. Certainly not in that language, and more profoundly, not in that conception, that there are some things that the individual absolutely cannot be intruded upon, cannot be infringed. There's some sphere of liberty or freedom that the individual cannot have violated by the state. And so these distinctive features of the U.S. Constitution, it's written, it's supreme, it protects individual rights while enumerating powers, become the distinctively American tradition of constitutionalism.